So, ICC Uniform Customs and Practice for Documentary Credits, and the version is UCP 600. This is the latest revision of the Uniform Customs and Practice that govern the operations of letter of credit. And this came into effect on July 1st, 2007. It contains 39 articles and it is very comprehensive and practical work which can help to bankers, lawyers, importers and exporters, transport executives, educators, and everyone who is involved in the letter of credit transactions worldwide, whether they are business people or some financial institution or educational institution or teachers, all people who are in any way connected to this. So it is a practical working aid to all those people. And the latest revision version, it is UCP 600. UCP 600 means Uniform Customs and Practice 600. Earlier it was called UCPDC. UCPDC. It is same Uniform Customs and Practice for Documentary Credits. Now it is written as UCP 600. And International Chambers of Commerce. It is the main organization which works on it and frames the guidelines. So without going into the background how it was, so when it started, let us come direct to the sections, articles in that. So let us come direct to that. So it is Article 1. Article 1 talks of the application of UCP, that where it will be applied, UCP 600. It states that the UCP 600 are rules that apply to any documentary credit. Documentary credit is letter of credit. Any documentary credit, including any standby letter of credit, when the text of the credit expressly indicates that it is subject to these rules. They are binding on all parties thereto unless expressly modified or excluded by the credit. So it applies to all credits, letter of credits, where the text of the credit expressly indicates that it is subject to these rules. It may or may not apply if the clause is not there, line is not there, that it is subject to UCP 600. If the it does not expressly indicate, then it may or may not apply. So it is necessary in incorporate this line. It is subject to UCP 600. So it is about application. Second part is definitions, means different parties, different terms which are there in the documentary credit. So start alphabetically starting from that. Advising bank. Advising bank is a bank that advises the credit at the request of the issuing bank. So before that, let us discuss a little the structure of letter of credit, how a letter of credit works. Only then these terms or definitions will be more understandable and more convenient to know and understand. Now you see, there is one person who wants to import something. He who wants to import something, but he doesn't know the exporter, from other country, or seller from other country, and seller doesn't know the buyer. So when they just have a dialogue relating to import of the items, the seller says, okay, you get me issued a letter of credit from your country, any bank from your country acceptable to the, of course, acceptable to the seller, and he goes to his bank. The buyer goes to his bank that, yes, sir, I want one letter of credit with the following details. And that person is called applicant. Means applicant means the party on whose request the credit is issued. So applicant goes to his own bank, and that bank is, after completing some formalities, it will issue the letter of credit, and this bank is called issuing bank. Issuing bank means the bank that issues a credit at the request of an applicant or on its own behalf, sometime on its own behalf also. So it is called, if even if issuing bank is importing something for its own behalf, so it will be issuing letter of credit on its own behalf. Otherwise, it issues always at the request of the applicant. So applicant is a person who wants to import something. He goes to his bank and tells the terms and conditions, and on the basis of, after completion of certain formalities, the issuing bank issues the letter of credit. Then there is one more party, that is advising bank. Advising bank means a bank that advises the credit at the request of the issuing bank. So issuing bank requests some bank, maybe in the country of the seller, or with whom the banks of seller countries have arrangement. It will request that bank to advise the letter of credit. It is called advising bank. Now sometimes what happens, that the seller says, I don't know the standing of your bank, issuing bank. I don't know the credit worthiness of the issuing bank. He says, I want a confirmation from some international bank, or some bank which is commonly accepted to both of them. And he says, okay, the LC has been issued, but it must be confirmed by some other bank which is acceptable to both the parties. And this process is called confirmation. Means, and the bank who does it, it is called as confirming bank. So confirming bank means the bank that adds its confirmation to the credit upon the issuing bank's authorization or request. Means issuing bank will request the confirming bank that you please confirm our LC. Of course, they have some arrangements, only then they do it, and they charge also for that. So confirming bank will add confirmation to that letter of credit. It means after confirmation, confirming bank also takes undertaking. It is just like an undertaking indirectly, that in case issuing bank fails to make payment of the LC, confirming bank is responsible to make payment. So this is confirmation or confirming bank, like this. After that, this letter of credit is advised to the beneficiary. Beneficiary who is a person? The person who is a seller, in whose favor the LC has been issued. And beneficiary, what it will do, he'll just get the things ready, and after supply of the goods, in terms of letter of credit, we will go through the details, what can be the terms, because everything cannot be covered in this aspect. So he prepares, packs and sends the goods as per agreed terms, everything, and prepares the papers, documents. Because we will see in another sections that the banks deal with documents only, not in goods. So he prepares the documents, everything as per system, as per the terms settled between them and which have already been mentioned in the letter of credit, and it goes to its own bank that this is letter of credit. I have gone through everything, I have done everything, and now these are the documents for this collection of money. So there can be more than one ways. One is that it tells its banker that okay, you collect the money on my behalf because I don't want the money. If he has ample funds with him, he has sufficient funds with him to fulfill that order, to complete that order, he'll say, okay, you please collect this money on my behalf. Secondly, he will tell us to negotiate that. Negotiate that. Negotiate means the banker of the seller or beneficiary's bank. It will study all terms and conditions mentioned in that letter of credit and just compare the documents. And if the documents are in order, it will just negotiate those documents, and it will give the money will be after negotiation, the money will be credited to the account of the beneficiary. And the negotiating bank, it will send the documents to the issuing bank for payment, and the issuing bank, after verification of all documents, of course some time is given for verification, and all these clauses articles are there, we'll go through that. Means here we can say after satisfying about the terms and conditions, or about the terms and conditions mentioned in that what type of documents are required, packing list or everything, country of origin and all these things, then after satisfying that it is strictly documents are strictly as per the letter of credit, then it will make payment on behalf of the applicant. If the funds are there, then it will debit applicant's account and immediately send the money. And if the funds are not there, still it is bound to make the payment. It will make payment from his own, normally it is due date default, and then recover the amount from the applicant. This is the process. So issuing bank means the bank that issues a credit at the request of the applicant. Negotiation is the process, means the purchase by the nominated bank of drafts. Means some banks are nominated that it can be negotiated or purchased here. It is at the request of the beneficiary. And nominated banks means the bank with which the credit is available, or any bank in the case of credit available with any bank. Presentation means either the delivery of documents under a credit to the issuing bank or nominated bank, or the documents so delivered, means delivery of documents to a banker after execution of the order. And presenter definitely means a beneficiary, bank or other party that makes a presentation. So all these terms are there. Credit is here, the credit means a documentary credit, or you can say letter of credit. And now from UCP 600 onward, it is always irrevocable. Even if it is not mentioned in the terms, but it is subject to UCP 600, it automatically means that the letter of credit is irrevocable. So now you can just see what is meant by irrevocable. Irrevocable is a document which cannot be changed without consent of all the parties involved. So, letter of credit as per UCP 600, it is always irrevocable. But if the buyer and seller, both the parties, they agree to something, thereafter even it can be, the terms can be changed. But it cannot be changed unilaterally, that if importer says or applicant says that you change it, it cannot be changed. If beneficiary says it should be changed, it cannot be. Because as per UCP, all documentary credits are irrevocable. Now we see thereafter Article 3. Article 3 gives some interpretations. As I have already discussed, that it is irrevocable. There is, even if there is no indication, it can be signed in handwriting also. Yeah, facsimile signature can be there. The perforated signatures can be there. Stamp, symbol, or anything, which is the only any acceptable method, it can be signed accordingly. So where there is a requirement of a document to be legalized, it must be legalized before that. Branches of a bank in different countries are treated as separate banks. This is very important. Branches of a bank in different countries is treated as a this separate banks. So these are few this interpretations. Then Article 4, it makes a distinction between credits and contracts. So credits and contracts, you see, a contract may contain many credits. A contract is for, suppose there is a contract for supply of one item by a seller to the buyer for 1 year, maybe for 3 year, maybe it is for 5 years. So it depends that for how long that contract is valid. But it may contain it may contain many credits. But credit generally, one credit generally has one contract. But yes, if it is revocable, again the contract is there, but some condition can be there, that when if the contract is, because LC normally it doesn't have any condition, So normally credits can be many, but for one credit, contract is only one. So credit by its nature is a separate transaction from the sale or contract on which it is based. So credit is based on a contract, you can say. It may be a verbal contract, it may be a written contract. It depends upon the understanding between the applicant and the beneficiary, or you can say a buyer and a seller. So this is Article 4. Then you see Article 5. It talks about documents versus goods. And it clearly speaks banks deal with documents, not with goods, services, or performance to which documents may relate. Banks deal with documents and not with goods, services, or performance to which the documents may relate. So they have clearly mentioned the bankers are not supposed to check the contents of the cargo, that what the seller has sent. If the documents are strictly according to the terms of letter of credit, it is understood that banks will accept it, because banks deal with documents, not with goods, services, or performance of the to which the documents may relate. Now, Article 6. Here it depends upon it talks about some other terms: availability, expiry date, and place of presentation. So point A speaks, a credit must state the bank with which it is available, or whether it is available with any bank. A credit available with a nominated bank is also available with the issuing bank, definitely. So A credit must state the bank where it is available, because it can be presented there only. It cannot be presented in any of the banks. No, some bank is nominated bank for that purpose where it is available. Or it can be sent direct to issuing bank also. But again, if the beneficiary sends direct to issuing bank, the money must go to some banker, some account. So he has to mention that in that. And again, whether a credit must state whether it is a side payment, deferred payment, it is payable on acceptance or negotiation. All these things should be there. Next point is a credit must not be issued available by a draft drawn on the applicant, because it is always drawn on a banker. It is an undertaking by a banker. So it must be issued by a banker, and the undertaking also must be of a banker. Then last, a credit must state an expiry date of presentation, means by which date the credit must be presented. And if the credit is presented thereafter, it will be treated as presented on expiry date. Then place of presentation must be there. If the name of the bank is there and place of presentation is not there, it means it is open to be presented in any of the branches of that bank wherever they are. No, it is not so. Place of presentation must be there, that where this should be presented. And except there is one sub article 29A, a presentation by or behalf of beneficiary must be made on or before of the expiry date. Means this article 29A, it contains some of the exceptions. So except that, which is specifically mentioned also, the presentation must be made on or before the expiry date. Now article 7. So article 7, it talks about undertaking. Provided that stipulated documents are presented to the nominated bank or to the issuing bank and they constitute a complying presentation, the issuing bank must honor if the credit is available by side payment, deferred payment, or acceptance with the issuing bank. Side payment with a nominated bank, that nominated bank does not pay. Deferred payment with a nominated bank, and that nominated bank does not incur its deferred payment undertaking. So all these things are there, that if the commitment of at one level is not complied with, issuing bank must honor, because issuing bank is the final paying authority. Even if the customer does not pay, customer doesn't have, this applicant doesn't have balance in his account, still the issuing bank is bound to make the payment, because it has undertaken. So as per clause B and of article 7, an issuing bank is irrevocably bound to honor as of the time it issues the credit. Even if the applicant goes bankrupt, still the applicant bank is bound to make the payment, because it has given the undertaking. Then confirming bank undertaking. Now you see, the ultimate liability is of issuing bank, but when confirming bank confirms that, indirectly it steps into the shoes of issuing bank. If issuing bank fails to make payment, confirming bank by all means has to honor the liability. So it states confirming bank undertaking, about confirming bank undertaking, provided that the stipulated documents are presented to the confirming bank or to any other nominated bank, and that they constitute a complying presentation, the confirming bank must honor if the credit is presented by side payment, deferred payment, or acceptance by the confirming bank. So it is all about the duties of the confirming bank. Now, Article 9, it speaks about the amendments, advising of credit and amendments. Advising that this should be advised by an advising bank. So there is a difference between advising bank and confirming bank. The main difference is of liability only. And advising bank and confirming bank may be two different banks, may be the same bank also. Advising bank only advises that this is documentary credit and I am advising this. Advising, it is only the services to advise, maybe original this LC or any subsequent change in the terms and conditions as per mutual consent of the parties involved thereto. But confirming bank adds confirmation to the letter of credit issued by the issuing bank, and it is just like an undertaking by issuing bank that in any way if issuing bank fails to make the payment of that credit, confirming bank will make the payment. So this is about advising of credit and any subsequent amendments. Then Article 10, it talks about the amendments. Except as otherwise provided by Article 38. We'll go through Article 38 later. There are some terms, some conditions under which it can be amended. But except those conditions, a credit can neither be amended nor cancelled without the agreement of the issuing bank, the confirming bank, if any, and the beneficiary. So everyone involved in that, it cannot be amended or cancelled except what is mentioned in Article 38. An issuing bank is irrevocably bound by the amendment as of the time it issues the amendment. So the terms and conditions of the original credit will remain in force for the beneficiary until the beneficiary communicates its acceptance of the amendment of the bank that advised such amendment. Means there was one original letter of credit and subsequent there was some amendment. Okay. Now there is another way also that issuing bank sends an amendment. Amendment is advised to the beneficiary, and if beneficiary gives consent to that amendment, again it is treated as accepted, and again there is no violation of the terms of irrevocable letter of credit because they have this advised the amendment and he has accepted like this. So this speaks about the amendments. So up to Article 10 is covered in this. We'll cover the Article 11 to 39 thereafter. Okay. So Article 11 of UCP 600, it talks about the tele-transmitted and pre-advised credits and amendments. And the crux of the things is that it should be transmitted only through authenticated transmission methods. Any subsequent mail not sent through authenticated transmission, it will be disregarded. And moreover, anything which is transmitted without the consent of all the parties, it is subject to be disregarded. So Section 11, Article 11 speaks about this, how the messages or the credits are to be transmitted. Then Article 12, we'll be going with these articles uh, just hurriedly, because some of the articles are very important. We'll discuss them, but otherwise we'll go in a little hurry. So Article 12, it speaks about the nomination. So it speaks, unless a nominated bank is a confirming bank, an authorization to honor or negotiate does not impose any obligation on that nominated bank to honor or negotiate, except when expressly agreed to by that nominated bank and so communicated to the beneficiary. So it is about the bank which is nominated for making, authorizing or negotiating the bills or documents which have come under documentary credit. So it depends upon the authority given by the issuing bank and the relationship. So confirming bank has the obligation to honor the documents even if they have been rejected by the issuing bank. But other nominated banks, they have to operate according to the instructions given to them. Article 13. Article 13 speaks about the bank-to-bank reimbursements arrangements. So it speaks about the arrangements, how the bank-to-bank maybe for reimbursement, it may pass through more than one bank according to arrangements of the beneficiary as well as the issuing bank. But again, everything is to be done as agreed between all the parties. Then Article 14. This is very important. This is about this examination of documents. So, as per UCP 600, a time frame has been given for examination of documents, and earlier, before 600, it was 7 days, and that too was 7 working days. But now it has been uh, clearly expressed that a nominated bank acting on its nomination, a confirming bank and the issuing bank, shall each have a maximum of 5 banking days. Again, banking days means when they work. Banking days means working days. In between, it is not so that today is a banking day and in between there is 5 day holiday and all those 5 days period will go. No. Now they have clearly mentioned 5 banking days following the day of presentation. So following the day of presentation is not counted. So any bank, maybe a nominated bank or a confirming bank or issuing bank, they have mentioned each have a maximum of 5 banking days following the day of presentation to determine if the presentation is compliant. Means if the documents are as per terms of the documentary credit (LC). And in case there is some discrepancy, they can point out the discrepancy to the beneficiary or the beneficiary's bank. They can. But everything, it will come in subsequent also, that before sending the telling the discrepancy to beneficiary and its bank, they may consult, issuing bank may consult the applicant, and if applicant agrees to those terms, then there is no need of sending that. Again, if presentation including one or more original transport documents must be made not later than 21 calendar days after the date of shipment. Means the documents to be submitted, original transport documents and other related documents, it must be presented within 21 days. It must not be presented later than 21. Here it is calendar days, not it is banking days. Earlier it was 5 banking days, but here it is 21 calendar days. Even if all 21 days are holidays, they don't, because exception is maybe a little different. But yes, here they have given that on behalf of the beneficiary, because there are some exceptions also subject to Article 1922, all these things. But yes, in general they have given 21 calendar days after the date of shipment. So similarly, there are some other factors in next this articles, but the important is 5 day and 21 day. Now we are going with article 15. So it is about complying of presentation. When issuing bank determines that a presentation is complying, it must honor. Complying means what? When issuing bank finds the documents as per the terms of the documentary credit, or if the discrepancy is there, it has been accepted by the applicant, then it is said that it is complying. And when he find determines that presentation is complying, then it must honor. It must honor. Honor means make payment, definitely, as per the terms mentioned in the documentary credit. Then Article 16. It speaks about discrepant documents, waiver and notice. As I told you earlier, discrepant documents can be there. And issuing bank, when it just determines that yes, this discrepancy is there, it may refer the discrepancy to applicant. And if the applicant accepts that discrepancy, in case he doesn't have any objection, then the documents will be treated as compliant, and it must honor the commitment as per the documentary credit. So this is like that. Then we come to Article 17. It tells about the original documents and copies. So the compliance must be for the original documents, and original documents are which are typed originally, stamped. They carry original stamps. They carry original signatures. They cannot honor the commitment on the basis of copies of the documents. All documents must be original ones. Then this article 18. 18 speaks about the commercial invoice, how commercial invoice must be. There are some exceptions as per article 38, but yes, means how a commercial, because subsequent articles they speak about all type of documents, that what type of document they should be, and it is very simple that what it must appear to have been issued by the beneficiary, because commercial invoice is issued by the beneficiary when he prepares the goods. The goods are ready and it transports the same, so it prepares, before transporting it prepares a commercial invoice, that this is the cost, this is the price, these are the taxes, all these things. There is a commercial invoice, and it must appear to have been issued by the beneficiary. Secondly, must be made in the name of the applicant, and third, must be made out in the same currency as the credit. Okay, and must be signed, and if required, stamped also. And all these factors and any other thing which is required to be mentioned in that, it must be mentioned as per the terms of the documentary credit, because all the documents are required to be as per terms of the documentary credit. Then transport document, so they must at least covering at least two different modes of transport. Means suppose there is a combined transport or multimodal transport, different models of transport are there. They must indicate the name of carrier and must be signed by the authorized person. uh, Means all details relating to the carrier, it must be there, and it should be signed by the master or agent of the carrier. Then next is, because all these articles, another few articles, they are relating to documents only. Then bill of lading, means bill of what should be there in the bill of lading. A bill of lading must indicate the name of the carrier and must be signed by the carrier or his named agent or the master, like this. So again, next is article 21. It speaks about non-negotiable sea-way bill. Again, indicate the name of the carrier and it must be signed by the authorized agent, or for or on behalf of the carrier, or may be signed by the master or agent of the means all again same things are there, but again all the documents are required to be as per the terms mentioned in the documentary credit. Charter bill of lading, same thing. So next we are coming Article 23, 22 speaks about the charter bill of lading. 23 speaks about the air document, air transport document, and then Article 24 speaks about the road, rail, and inland waterway transport documents. Means, and everywhere it is there, it must be signed by the persons authorized to sign them. It must be stamped if required, and if the agent is signing, it must sign on behalf of the master. Then courier receipt, post receipt, and certificate of posting. Courier receipt must indicate the name of the courier service. The courier must be authorized one between the buyer and seller, because sometimes they fix in the terms also the goods will be sent through this particular courier. If the terms of the credit speak about that, then it must be mentioned there that yes, this courier also is required, and the goods should be sent through the same courier. Then Article 26. Article 26 speak about the goods on deck load and count said by the shipper to contain and charges additional to freight. So it speaks about the load and count or the freight. A transport document must not indicate that the goods are or will be loaded on deck. A clause on transport document stating that the goods may be loaded on deck is acceptable. A transport document bearing a clause such as shipper's load and count and said by shipper to contain is acceptable. A transport document must bear a reference by stamp or otherwise to charges additional to freight. Means if the charges are there additional to freight, it must be mentioned in that. Then Article 27. It speaks about the clean transport documents. Clean transport documents are those documents which don't bear any clause or notation declaring a defective condition of goods or their packaging. If there is some clause declaring that goods are in the packaging is in not order, the packaging is not perfect, or the goods are not in good condition or defective condition, it should not be accepted. The transport document should be very, very clear. They should not accept, transport authority, they should not accept any document, any goods or item, or they have to check the packaging also. It should not be, the goods should not be in defective condition, or the packaging should not be in the defective condition. Then Article 28, it speaks about the insurance, and an insurance document such as insurance policy or insurance certificate or declaration under open cover must appear to be issued and signed by the insurance company or underwriter or their agent. And cover note will not be accepted, only a policy will be accepted. Only a policy will be accepted. And insurance, this is very, very important clause, that if there is no indication in the credit of the insurance cover required, the amount of insurance cover must be at least 110% of the CIF or CIP value of good. Cost, insurance, freight, CIP value or CIP value of the goods. If it is mentioned, sometimes they mention it should be 120% of the CIF or CIP. But if it is not mentioned at all, the cover must be at least 110%. This is very important, 110%. And in case CIF or CIP value cannot be determined from the documents, the amount of insurance coverage must be calculated on the basis of the amount for which honor or negotiation is requested, or the gross value of goods as shown in the invoice, and whichever is greater. So it should be done like this. Then Article 29, it speaks about the expiry date of the credit and when it falls. Means if the expiry date of a credit or the last day for presentation falls on a day when the bank to which presentation is to be made is closed for reasons other than some reasons referred in Article 36, the expiry date or the last day of presentation, as the case may be, will be extended to the first following banking day. There are some reasons for closure in Article 36. But if a bank remains closed for any reason other than that, the expiry date will be extended to the first following banking day, next working day, which is called in general terms. Okay. Then tolerance in credit amount, quantity and unit price. Credit amount tolerance level is 10%, more or less, plus minus 10%. Means if the invoice, this documentary credit is for 100 million, so acceptable level is either up to lowest up to 90 million, highest up to 110 million. So it is, but the quantity wise, it should not be more than 5%. Tolerance level is 5%, more or less than 5%. And where even partial ships are not allowed, again that this tolerance level is 5%. So there are some levels that if something is not mentioned, then tolerance level but should be there. Amount wise it should be 10% plus minus, and quantity wise it should be 5% plus minus. And in case of partial shipment also, not more than, if they are not allowed, then it is again 5%. Then Article 31, it speaks about the partial drawings or shipments. If it is allowed, then of course it should go as per the terms of documentary credit, and if not allowed, again how it is to be done, all has been mentioned in Article 30 as well as Article 31. Now we are talk about Article 32. It depends upon, it tells about the installment drawings or shipments. If a drawing or shipment by installments within given period is stipulated in the credit, and any installment is not drawn or shipped within the period allowed for that installment, the credit ceases to be available for that and any subsequent installment. So it is very clear in that installment drawings, if installment drawings or shipments are there again mentioned in the credit, and any installment is not drawn or shipped within the period allowed for that installment. Suppose all the goods are to be shipped in 4 installments, and one installment is to be shipped within 20 days. Okay, if that installment has not been shipped within 20 days, the credit ceases to be available for that installment as well as any subsequent installments. Reason being, there is a default on the part of the beneficiary, and the goods have not been shipped within that period, and when the goods have not been shipped within that period, so the credit ceases to be available for that as well as any subsequent installments. This has been given in the Article 32 of the UCP 600. Now we are talking about the Article 33. So it speaks about the hours of presentation, and it's very clear that bank has no obligation to accept a presentation outside the banking hours. Suppose the banking hours are from 10 to 4. So the documents must be presented within this time. If somebody comes at 8 o'clock and it knocks at the agent's door that yes, this is the last day and I want to present these documents, those will not be accepted at all, because Article 33 very clear speaks about the hours of presentation, and it speaks that it is under no obligation to accept a presentation outside the banking hours. Then Article 34, it is about the disclaimer of on effectiveness of documents, that bank doesn't assume any liability whatever documents have come. If there is some insufficiency or accuracy or genuineness, falsification, nothing, because the documents must be in terms of the documentary credit, and if documents appear to be in terms of the documentary credit, then the bank does not assume any liability or responsibility for that. It is very well within its right to honor the commitments as per documentary credit. Then Article 35, it speaks about the disclaimer on transmission and translation. So again, if there is some problem due to transmission or translation or something, again the bank does not assume any liability. Then Article 36, it speaks about the force majeure. This is a new article which has been added in UCP 600, because prior to UCP 600, no article was there to speak about the force majeure. And what is force majeure? It means something happens unexpectedly. Maybe some civil rights are there, some war is there, some acts of terrorism are there, or strikes, lockouts, any such things are there. In that condition, the this bank assumes no liability or responsibility, because it is something which happens due to the reasons beyond their control. Okay, so a bank will not, upon resumption of the business, honor or negotiate under a credit that expired during such interruption of its business. Then Article 37, it's disclaimer for acts of the instructed party. Means, again, if some of the instructed party makes any deviation or something is there, but all the documents are as per the terms of the credit, then the bank is very well within the rights to honor that. Then Article 38, it speaks about the transferable documents, credits. Transferable credits are the credits which can be transferred to other beneficiary also. And if it is specifically mentioned in the documentary credit, only then it is acceptable by the issuing bank. That if the credit has been transferred without the consent or without the terms mentioned in the documentary credit, then the bank assumes no liability. And then coming to the last point, it is Article 39. It speaks about the assignment of proceeds. A beneficiary cannot assign the proceeds to anybody else unless until it has been specifically mentioned in the documentary credit. So this is all about UCP.